Good morning, sir. I'm Michelle Saguirre, BSIT 3C PBO. Today, we will report titled Cybercrime Law, Republic Act of 1019-5. Chapter 1, Preliminary Provisions. Section 1, titled, This Act shall be known as the Cybercrime Prevention Act of 2012. Sec 2, Declaration of Policy. The state recognized the vital role of information and communication industries such as content production, telecommunication, broadcasting, electronic commerce, and data processing in the nation's overall social and economic development. The state also recognized the importance of providing an environment conducive to the development, acceleration, and rational application and exploitation of information and communication technology to attain free, easy, and intelligible access to exchange in and/or delivery of information, and the need to protect and safeguard the integrity of computer and communication system networks and database, and the confidentiality, integrity, and availability of information and data stored therein from all forms of misuse, abuse, and illegal access by making punishable under the law such conduct or conducts. In this light, the state shall adopt sufficient power to effectively prevent and combat such offenses by facilitating their deduction, investigation, and prosecution at both the domestic and international levels, and by providing arrangement for fast and reliable international cooperation. Sec. 3. Definition of terms. For purpose of this act, the following terms are hereby defined as follows. A. Access refers to the instruction, communication with, storing data in, retrieving data from, or otherwise making use of any resources of a computer system or communication network.
B. Alteration refers to the modification or change in form or substance of an existing computer, data, or program. C. Communication refers to the transmission of information through ICT media, including voice, video, and other forms of data. Chapter 2. Punishable Acts. Section 4. Cybercrime Offenses. The following acts constitute the offense of cybercrime punishable under this act. Offenses against the confidentiality, integrity, and availability of computer data system. Illegal access. The access to the whole or any part of a computer system without right. Illegal interception. The interception made by technical means without the right of any non-public transmission of computer data to from or within a computer system, including electromagnetic emissions from a computer system carrying such computer data. Data interference. The intentional or reckless alteration, damaging, deletion, or deterioration of computer data, electronic document, or electronic data message without right, including the introduction or transmission of viruses. System interference. The intentional alteration or reckless hindering or interference with the functioning of a computer or computer network by inputting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or program, electronic document or electronic data message without right or authority, including the introduction of transmission of viruses. Misuse of devices. The use, production, sale, procurement, importation, distribution, or otherwise making available without right of a device, including a computer, program, designed or adapted primarily for the purpose of committing any of the offenses under this act, or a computer password, access code, or similar data by which the whole or any part of a computer system incapable of being accessed with intent that it be used.
for the purpose of committing any of the offenses under this act. CC. The possession of an item referred to in paragraphs 5I, AA, or BB above with intent to use said devices for the purpose of committing any of the offenses under this section. 6. Cyber squatting. The acquisition of a domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same if such a domain name is I. Similar, identical, or confusingly similar to an existing trademark registered with the appropriate government agency at the time of the domain name registration. 2. Identical or in any way similar with the name of a person other than the registrant in case of a personal name. And 3. Acquired without right or with intellectual property interest in it. Next, computer-related fraud. The unauthorized input, alteration, or deletion of computer data or program or interference in the functioning of a computer system, causing damage thereby with fraudulent intent, provided that if no damage has yet been caused, the penalty impossible shall be 1 degree lower. 3. Computer-related identity theft. The intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical, without right, provided that if no damage has yet been caused, the penalty impossible shall be 1 degree lower. 1. Cybersex. The willful engagement, maintenance, control, or operation directly or indirectly of any lascivious exhibition of sexual organs or sexual activity with the aid of a computer system for favor or consideration.
Child pornography, the unlawful or prohibited acts defined and punishable by Republic Act Number 9775 or the Anti-Child Pornography Act of 2009, committed through a computer system, provided that the penalty to be imposed shall be 1 degree higher than that provided for in Republic Act Number 9775. Unsolicited commercial communications, the transmissions of commercial electronic communication with the use of computer system which seek to advertise, sell, or offer for sale products and services are prohibited unless there is prior affirmative consent from the recipient. Libel, the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended committed through a computer system or any other similar means which may be devised in the future. Other offenses, the following acts shall also constitute an offense: a. Aiding or abetting in the commission of cybercrime. Any person who willfully abets or aids in the commission of any of the offenses enumerated in this act shall be held liable. B. Attempt in the commission of cybercrime. Any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. Crimes defined and penalized by the Revised Penal Code as amended and special laws if committed by, through, and with the use of information and communication technologies shall be recovered by the relevant provisions of this Act, provided that the penalty to be imposed shall be 1 degree higher than that provided for by the Revised Penal Code, as amended, and special laws, as the case may be. Liability under other laws. A prosecution under this Act shall be without prejudice to any liability for violation of any provision of the Revised Penal Code as amended or special laws.
Chapter 3, Sec 8, Penalties. Any person found guilty of any of the punishable acts enumerated in Sections 4A and 4B of this act shall be punished with imprisonment of prison mayor or a fine of at least 200,000 pesos up to a maximum amount commensurate to the damage incurred or Sec 9. Corporate liability. When any of the punishable acts herein defined are knowingly committed on behalf of or for the benefit of a juridical person by a natural person acting either individually or as part of an organ of the juridical person who has a leading position within based on a power of a representation of the juridical person provided the act committed falls with, within the scope of such authority. An authority to take decisions on behalf of the juridical person provided that the act an authority to exercise control within the juridical person. The juridical person shall be held liable for a fine equivalent to at least double the fines impossible in Section 7 up to a maximum 10 million pesos. Chapter 4 Enforcement and Implementation. Sec 10 Law Enforcement Authorities. The National Bureau of Investigation or NBI and the Philippine National Police or PNP shall be responsible for the efficient and effective law enforcement of the provisions of this act. The NBI and the PNP shall organize a cybercrime unit or center manned by special investigations to exclusively. Second element, duties of law enforcement authorities to ensure that the technical nature of cybercrime and its prevention is given tools and considering the procedures involved for international cooperation, law enforcement authorities, especially the computer or technology crime divisions or units responsible for the investigation.
Cybercrimes are required to submit timely and regular reports including pre-operation, post-operation and investigation result and such other documents as may be required to the Department of Justice or DOJ for review and monitoring. Sec 12. Real-time collection of traffic data. Law enforcement authorities and due course shall be authorized to collect or record by technical and electronic means traffic data in real time associated with specified communications transmitted by means of a computer system. Sec 13. Preservation of computer data. The integrity of traffic data and subscriber information relating to communication service provided by a service providers shall be reserved for a minimum period of 6 months from the date of the transaction. Content data shall be similarly preserved for 6 months from the date of receipt of the order from law enforcement authorities required its preservation. Sec 14. Disclosure of computer data. Law enforcement authorities, upon securing a court warrant, shall issue an order requiring an person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in his or its possessions or control within 72 hours from receipt of the order in relation to valid complaint officially docketed and assigned for investigation, and the disclosure is necessary and relevant for the purpose of investigation. Sec. 15. Search, seizure, and examination of computer data. Where a search and seizure warrant is properly issued, the law enforcement authorities shall likewise have the following powers and duties.
Section 16. Custody of computer data. All computer data, including content and traffic data, examined under a proper warrant shall within 48 hours after the expiration of the period fixed therein be deposited with the court in a sealed package and shall be accompanied by an affidavit of the law enforcement authority. Executing it stating the dates and times covered by the examination and the law enforcement authority who may access the deposits, among other relevant data. Law enforcement authority shall also certify that no duplicates or copies of the whole or any part thereof have been made, or if made, that all such duplicates or copies are included in the package deposited shall not be opened, or the recording replayed or used in evidence, or then contents revealed except upon order of the court, which shall not be granted except upon motion, with due notice and opportunity to be heard to the person or persons whose conversation or communication have been recorded. Section 17. Destruction of computer data. Upon expiration of the period as provided in Section 13 and 15, service providers and law enforcement authorities, as the case may be, shall immediately and completely destroy the computer data subject of a preservation and examination. Section 18. Exclusionary Rule. Any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal.
Sec 19. Restricting or blocking access to a computer data. When a computer data is prima facie found to be in violation of the provision of this Act, the DOJ shall issue an order to restrict or block access to such computer data. Sec 20. Non-compliance. Failure to comply with the provision of Chapter 4 hereof, specifically the orders from law enforcement authorized, shall be punished as a violation of Presidential Decree Number 1829 with imprisonment of prison correctional in its maximum period of fine of 100,000 pesos or both for each and every non-compliance with an order issued by law enforcement authorities. Chapter 5. Jurisdiction. Section 21. Jurisdiction. The regional trial court shall have jurisdiction over any violation of the provision of this Act, including any violation committed by a Filipino national, regardless of the place of commission. Jurisdiction shall lie if any of the elements was committed within the Philippines or committed with the use of any computer system wholly or partly situated in the country, or when by the such commission any damage is caused to a natural or juridical person who at the time the offense was committed was in the Philippines. Chapter 6. International Cooperation. Section 22. General principles relating to international cooperation. All relevant international instrument or international cooperation in criminal matters. Arrangement agreed on the basis of uniform or reciprocal legislation and domestic laws to the widest extent possible for the purposes of investigation.
Proceedings concerning criminal offenses related to computer systems and data or for the collection of evidence in electronic form of a criminal offense shall be given full force and effect. Competent authorities, Department of Justice, there is hereby created an Office of Cybercrime within the DOJ designated as the central authority in all matters related to international mutual assistance and extradition. Cybercrime Investigation or Coordinating Center. There is hereby created within 30 days from the effectivity of this Act an interagency body to be known as the Cybercrime Investigation and Coordinating Center under the administrative supervision of the Office of the President for policy coordination among concerned agencies and for the formula and enforcement of the National Cybersecurity Plan. Composition: the CICC shall be headed by the Executive Director of the Information and Communication Technology Office under the Department of Science and Technology, as chairperson with the Director of the NBI as Vice Chairperson, the Chief of the PNP, Head of the DOJ Office of Cybercrime, and one representative from private sector and academy as members. The CICC shall be manned by a secretariat of selected existing personnel and representatives from the different participating agencies. Powers and functions: the CICC shall have the following powers and functions: to formulate a national cybersecurity plan and extend immediate assistance for the suppression of real-time commission of cybercrime offenses through a computer emergency response team (CERT).
B. To coordinate the preparation of appropriate and effective measures to prevent and suppress cybercrime activities as provided for in this Act. Chapter 8. Final Provisions. Sec 27. Appropriations. The amount of 50 million pesos shall be appropriated annually for the implementation of this Act. Sec 28. Implementing rules and regulations. The ICTO, DOST, the DOJ, and the Department of the Interior and Local Government, or DILG, shall jointly formulate the necessary rules and regulations within 90 days from approval of this Act for its effective implementations. Sec 29. Separability Clause. If any provision of this Act is held invalid, the other provisions not affected shall remain in full force and effect. Sec 30. Repealing Clause. All laws, decrees, or rules inconsistent with this Act are hereby repealed or modified accordingly. Section 33A of Republic Act number 8792, or the Electronic Commerce Act, is hereby modified accordingly. Sec 31. Effectively, this act shall take effect 15 days after the completion of its publication in the official gazette or in at least 2 newspapers' general circulation.